Good morning, my name is Bartłomiej ORƞZIAK and I am a member of the Central European Professors Network, exactly in the group The Impact of Digital Platforms and Social Media on Freedom of Expression and Pluralism, headed by Professor Marcin Wielec. I am also a coordinator of the Center for Strategic Analysis in the Institute of Justice in Warsaw, and a PhD last year student at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. I would like to thank the conference organizers for the opportunity to give this presentation, but also I would like to apologize for my absence, despite the fact that I really wanted to be together with you on the place. Unfortunately, health reasons have stopped me in Warsaw. However, going to the substantive part of my speech, today I will talk about Renckhoff case, C-161/17. It will be about internet content censorship and freedom of expression. In the first place, it is, in my opinion, important to present the background for this speech. Such a background and a normative point of reference is Directive 2001/29 of the European Parliament and of the Council of 22 May 2001 on the harmonization of certain aspects of copyright and related rights in the information society, after in my presentation just Directive 2001/29. It turns out that the bone of contention is Article 3, Paragraph 1 of this directive, and the concept of communication to the public of legally protected content by making it available on the internet, which can be referred to at least two basic groups of facts in specific cases. The first group is situation where some content was made available on the internet for the first time without the consent of the copyright holder. This means that legally protected content entered the internet illegally, so without the consent of the copyright holder or even against their will. And now it is the time to go to the main case of this presentation. It should be noted that the nature of the judgment of the Court of Justice of 7 August 2018 in the case C-161/17, Land Nordheim Westfalen versus Dirk Renckhoff, and after just in my presentation Renckhoff case, this nature is different. This case concerns situation where hyperlinks, links to the content communicated on the internet for the first time with the consent of the copyright holder. So this is the second group. Here we're linking, hyperlinking or sharing content legally available on the internet. For this reason, restrictions in this respect must be well justified, and it must be aware, or the author of this conception must be aware, for allegation of the freedom of expression violation or unlawful censorship. The facts of Renckhoff case refer to the situation where the student of preliminary school in Germany, as part of homework, used a photograph found on the internet. This was a photograph taken by Dirk Renckhoff that had been downloaded for some travel website with, what is in my opinion crucial, no restriction preventing it from being downloaded. And what is important, the photograph was available there legally, with the consent of the copyright holder. And under the photograph, the student placed a reference to the website from which it was downloaded. This homework was published on preliminary school's website, and Dirk Renckhoff, seeing that, brought an action before the National Court in Hamburg. And case go to the Court of Justice, which pointed out that the core of the problem is whatever the concept of communication to the public within the meaning of Article 3, Paragraph 1 of Directive 2001/29 must be interpreted as meaning that it covers the posting on one website a photograph which has been previously published without restriction and with the consent of the copyright holder on another website. In the Renckhoff case, the Court of Justice had no doubts that it was clear from the fact that the first criteria of communication to the public, namely act of communication, had been met, and proceed to analyze the second criteria. In my opinion, this is correct interpretation. The criteria that the protected work must be communicated to a public, in the opinion of Court of Justice, met if the communication was made to an indeterminate and fairly large number of potential recipients and was made using specific technical means different from those used for initial communication to the public. On the other hand, where the technical means were identical as in the Renckhoff case, it was necessary to determine whether the subsequent communication was to a new public, so to a public that was not already taken into account by the copyright holders when he, she authorized the initial communication to the public. The Court of Justice of European Union, based on the facts of the Renckhoff case, had no doubts that the second criteria of communication to the public was met as regards to the concept of new public. It is simple reasoning here, consisting of viewpoints. First of all, we have to have a protected work by copyrights work available on the internet. Secondly, we must check if this protected work was placed on the internet with the consent of the copyright holder or not. If this consent does not exist, we must use the principle and factors from GS Media case, for example, financial gain factor. This is the question about entity make communication for profit or not. However, if consent is, as the court noticed in Renckhoff case, we do not use a restriction model from GS Media case, as it is not applicable here. Here we are already interested in the scope of the consent of the copyright holder. If the range of this consent is unlimited, everything is all right. But if this consent is limited, for example, to one website, we must refer to the concept of a new public. This is also simple reasoning here. If the copyright holder consent for publication on the internet of his/her protected work is limited in relation, for example, to one website, the public is only viewers of this concreted website. Placing such protected work on a different website will be qualified as a fulfillment of the new public concept. And this results in the assignment of legal responsibility which can affect not only professionals but every internet user. Court of Justice also emphasizes, what is interesting, that the fact that copyright holder did not limit the possibility for internet users for use the photograph was irrelevant, as the enjoyment and the exercise of the right provided for Article 3, Paragraph 1 of the Directive 2001/29 may not be subject for any formalities. Court of Justice, in view of all arguments and the facts of the case, decided finally that the concept of communication to the public within the meaning of Article 3, Paragraph 1 of this directive must be interpreted as meaning that it covers the posting on one website of a photograph previously posted without any restriction preventing it from being downloaded and with the consent of the copyright holder. The Court of Justice approach in this case, in the Renckhoff case, seems peculiar. Apparently, nothing prevents Court of Justice from using the previously developed model for assessing the lawfulness of hyperlinking on the internet, which was known from other judgments about making available protected content originally placed on the internet without the consent of the copyright holder. So, in the Renckhoff case, the Court of Justice could well use the model of principles and criteria for determining the lawfulness of web hyperlinking. This was the best way of interpretation. The Court of Justice could have done this for the sake of demonstration of the logical consistency of its case law. However, the Court of Justice chose a different way, a different path of autonomous interpretation, despite it is difficult to find a reason for that decision. The Renckhoff case was not burdened with pejorative element as it was in the Pirate Bay case, for example. I can say more, that the facts favored the decision that the criteria communication to the public under Article 3, Paragraph 1 of the Directive 2001/29 had not been met. After all, the case is about a student presentation, so not only the freedom of expression, which should be respected, but also the right to education. What is interesting, Court of Justice state that its interpretation reflected the balance between, on the one hand, the interest of the holders of copyright and related rights, but on the other hand, the protection of the interest and fundamental rights of users of protected subject matter, in particular their freedom of expression. Nevertheless, the ruling of the case Renckhoff lacks proof of the truthness of this statement, and a mere statement is not sufficient. There is no in-depth analysis of this, of the essence of the freedom of expression, or maybe the right to education, a reference to the relevant case law, or an analytical summary that would confirm that the balance upheld by the Court of Justice is real. As these elements are missing in the text of the judgment, in the Renckhoff case, it seems that the Court of Justice claims for intellectual property rights, including copyright on the internet, to have the status of an absolute right. It seems that the Court of Justice position is that the balance between the right of the copyright holder and other legal norms, especially freedom of expression, is maintained only if the copyright is fully protected and without any precedents. This interpretative approach is defective and calls for a negative assessment. Of course, based on a relevant legal basis, for example, Article 10 European Convention on Human Rights or Article 31 of Constitution of Republic of Poland, freedom of expression or its constituent elements may be subject to limitations, of course, but only such that are legally justified. In the case of the Renckhoff judgment, it is difficult to demonstrate such justification. Let it suffice to indicate what consequences this judgment has in the practice of the functioning of the internet for the freedom of expression. In view of the fact that no factor of profit nature was used in the Renckhoff ruling, it actually applies to all internet users, not only to professionals. Since this ruling was issued, each internet user should each time obtain information about copyrighted content that they make available by a subsequent communication. More precisely, users should find out whatever, for example, a photograph that they share has been made available to the internet with or without the consent of the copyright holder, and if such consent was given, that what its extent is as to the subject permitted to communicate. Otherwise, they are putting themselves, like the student in the Renckhoff case, at risk of being held liable for copyright infringement. In the internet, hyperlinks are a tool that makes the freedom of expression. And to make a definitive conclusion in a situation where the copyright holder has consented to communication of their content on the internet, she should be aware of the consequences of such choice. One of the major consequences following from the nature of the internet is that a copyrighted work is communicated to the public across the web. Across the web, without any restrictions as to permitted territories, objects or subjects of communication, giving the unique nature of the internet consent of a copyright holder with a limited extent as to the subject permitted to communicate, for example, only to users of a selected website, should not have legal effects, in particular in view of the object of the freedom of expression. To summarize, in view of the above, the decision made by the Court of Justice of European Union in the Renckhoff case should also be critically assessed in terms of unjustified restriction of the freedom of expression on the internet. The argumentation and interpretation of Article 3, Paragraph 1 of the Directive 2001/29 adopted in the Renckhoff case appear to be incompatible with the specific nature and content communicated principles of the internet. The inaccuracy or even defectiveness of this ruling is one thing. The consequences it has for the realization of the freedom of expression on the internet in practice are another. It may paralyze hyperlinking in any form of the internet and thus disrupt the proper functioning of the internet and cause an unjustified limitation of the implementation of legal norms related to the freedom of expression in the digital environment. It should be clarified, emphasized that the comprehensive analysis carried out in this presentation leads to the conclusion that the court decision in the Renckhoff case may be deemed to be a normatively ungrounded restriction of the freedom of expression on the internet, of course. I think that the good solution would now be issued by the Court of Justice of the European Union, the judgment which will depart from the construction adopted in the Renckhoff case. Ladies and gentlemen, this accent I would like to end my speech. Thank you very much for your attention.